Hello and welcome to firesurvivorsvote.com, Survivor to Survivor. This is our new nuts and bolts series focusing on the PG&E reorganization plan, the plan explained. I'd like to introduce a few ground rules, or at least understanding of how we're going to proceed today. My name is Jason Meek, and I'm just going to serve mostly as a technical moderator and supporting Helen Sedwick, who's going to be delivering a presentation. I'll also be helping to facilitate addressing some of your questions that come in through the chat feature so that we can include all of your perspectives and concerns as we're trying to address some of the main aspects of the PG&E bankruptcy plan today. We've already received several questions through the online submission forms at www.survivorsvote.com, and we've taken some of those into consideration, but we're going to leave some time at the end for addressing some specific questions and also those that come through the chat feature. Just to mention, in terms of the chat and the way that it's operating, we've set some limitations in the sense that there's a delay in being able to send repeated chats onto the, or post repeated chats. So there's about a 2-minute delay in order to avoid some of the kind of trolling or botting that can go on. I would like to try to keep the chat comments to be relevant as much as possible to the commentary that Helen is offering, and then also addressing new questions that you might be prompted with as a result of hearing her dialogue or her presentation today. Again, Helen and I are both volunteers. We both lost our homes in the North Bay fires in 2017. And while we have a background in working with documents like this, we're really coming to this as in an explanatory, educative perspective, wanting to share just what we understand in terms of a summary of the documents, again, with a balanced and a balanced viewpoint so that you're better able to assess from the key terms as we anticipate the vote in the next couple of weeks. So without further ado, I'd like to welcome Helen Sedwick, and she'll give a little bit of a bio. I'm going to be controlling the slides from my computer, so you might see a little bit of lag time in terms of how the live stream is going, but just bear with us because, again, we're working on a shoestring staff and trying to present information in real time as best as possible. So, Helen?
Thank you, Jason. We just had one of those crises you always don't want, which is that half an hour ago, my computer decided to die. Thank goodness I had at least uploaded the second to last version of my slides onto Dropbox. So Jason will help me move through the slides because there's so much content here that I think the visual will help people absorb it. Well, as Jason said, we are both transactional attorneys, and we both lost our homes. I lost mine in the Nuns fire, which hit the southern Santa Rosa area on the same night as the Tubbs fire. I prepared this talk based upon publicly available information. I was not in the room for all the negotiations and the discussions behind closed doors, and I certainly have not read all the documents. But I've been active in just trying to help other fire victims understand the process. Sometimes the lawyers either speak in shorthand or they launch into sales pitches, and sometimes they're not as helpful as I think they could be. So I'm going to try to bridge that gap. Now, I'm sure I'm going to say something that some lawyer out there is going to find is a mistake in their view. And that is absolutely fine. If a lawyer out there sees that I've misspoken or that there need to be some clarifying details, I hope that you get in touch with your clients and you share that information, because that's what we're all about tonight, is information and getting it to you one way or another. I'm going to be using the word fire victims, even though I prefer the phrase fire survivors. But the word victim is what's used commonly in the legal documents. So it's just going to be easier for me to do that consistently throughout. So we're going to start the slides now, and hopefully this will work.
Here we go. I think
that's Howard, and that's what was left of our house the day after the fire. We were able to sneak in and get there before the police had really roped everything off and things were still smoldering. So let's go to the next slide, hopefully.
Okay, 1 second.
So how did we get here? In between 2015 and 18, PG&E caused a lot of major fires. They ended up destroying nearly 20,000 homes and killing at least 130 people. Their estimates of the total fire claims ranged anywhere from 30 billion to 54 billion. In light of the magnitude of that liability, PG&E filed for bankruptcy protection under Chapter 11. Let's go to the next slide. They didn't file because they were insolvent, but Chapter 11 gave them a way to reorganize their liabilities in a more manageable manner. And what the governor did in the California legislature, in order to push the bankruptcy along at a faster pace than most bankruptcies go, they passed this legislation that's commonly referred to as AB 1054. That creates a $21 billion wildfire fund that PG and other large utilities can draw from to cover fire claims. Not our fire claims, but claims arising after July 2019. But to qualify to draw from that fund, PG&E needs a confirmed plan of reorganization by June 30th. And it needs to make a contribution of $4.8 billion to the fund. And until it makes that contribution, it can only draw for up to 40% of its liabilities. So these deadlines are putting a lot of pressure on parties to move forward. So let's go to the next slide. Moving into Chapter 11 is a disadvantage for fire victims, in my view, because instead of taking our case to a jury, we're pulled into this process. It's really much more about keeping a business going. It's really organized and structured by debtors, investors, and creditors. And a bankruptcy plan is much more like a complex business transaction, where there is a lot of deference given to the debtor's business judgment. If you read any of the court documents, you'll see that one of PG&E's most consistent arguments for why they're doing what they're doing is that it's consistent with the business judgment rule. So it's not really a system that's designed to promote fairness or compassion. It's just not part of the structure. And the other thing that a bankruptcy does is it settles all the claims at one time, and PG&E isn't faced with 20,000 different lawsuits. So let's move on to the next slide. There are really two major sets of players in the bankruptcy. On one side, we have the debtors, which are really two debtors, PG&E Corporation, the parent, and Pacific Gas and Electric, which is the utility. And then there are the equity holders, the shareholders of PG&E Corporation, which is a publicly traded company. 85% of those or more are hedge funds or institutional investors. And a lot of the shareholdings are managed by Abrams Capital and Knighthead Capital. So often when we talk about negotiating with PG&E, what we're really talking about is negotiating with the major shareholders of PG&E. And the next slide, we talk about the other side of the bankruptcy parties, and that's the creditors. And there's a variety of different creditors, secured creditors, employees, pension funds, vendors, and unsecured creditors such as bondholders, public entities, FEMA, fire victims, and subrogation claim holders. A subrogation right or claim is your insurance company's right to seek reimbursement from PG&E for what it has paid you. In this case, most of our insurance companies have sold their claims to hedge funds generally, often at a substantial discount. So when we're talking about subro or subrogation claims holders, we're in about 80% of the cases, or 80% of the dollar amounts, talking about hedge funds. So let's look at the next slide. Okay. Before I start talking about how the plan treats us, unfortunately, there's a couple touchstones we need to deal with. First are some important dates. We're in the process of voting, and there's a deadline on May 15th. Currently, the confirmation hearing, which is in Judge Montali's court, which deciding whether the plan has been properly voted on and is ready to be confirmed, those will start. The deadline for participating in AB 1054s, June 30th. And now we get into some new concepts, the effective date. Effective date is when PG&E actually emerges from bankruptcy by issuing new stock, delivering cash to the various parties, and restructuring its debt. That was originally projected to be before August 29th. And starting August 30th, by contract, the TCC and the backstop parties could start backing out of this deal. I don't know whether they will. And then under a new agreement with the governor, if PG&E hasn't had an effective date before the end of the year, then a contingency plan goes into effect and PG&E is put up for sale. So let's look at the next slide. I'm going to focus on the treatment of fire claimants. So under the current proposed plan, PG&E will deliver to the Fire Victims Trust on the effective date, $5.4 billion in cash and $6.75 billion in common stock. The asterisk means that takes some explaining, and I'll get to that. Then there'll be some deferred payments, $650 million next January and $700 million the January after that. The trust is also getting an assignment of any rights that PG&E might have for indemnification or contribution from other third parties like tree trimmers or engineers or even officers and directors for any culpability they might have in causing the fires. So the plan is often called a $13.5 billion settlement. 13.5 is an approximation. It's not exactly that amount. So let's go to the next slide. So on the effective date, PG&E will also make some other payments. Subrogation right holders get $11 billion in cash. Public entities, which is 14 counties and cities and other governmental entities, get $1 billion in cash. No one else is getting stock. Then there's been lots of talk about claims from FEMA and the state, and those have been settled way down. And generally, they're either subordinated to our claims or they're coming out of third-party recoveries, what I talked about, the tree trimmers, or they're coming out of gain on the stock. And then PG&E's other debt is either being reinstated, refinanced, or paid in full. So let's look a little bit more at the trust, and we'll go to the next slide. Okay, this is an important thing that I think not everyone understands. All the fire claims are what are called channeled into the Fire Victims Trust. We can only look to the Fire Victims Trust for payment, and that includes whether you have an attorney or don't have an attorney, and it also includes people who never filed a proof of claim. The whole point of the bankruptcy is that these claims get channeled into one place and PG&E will be released and we go to the trust for payment. However, the definition of what goes into the Fire Victims Trust is very broad. This is how PG&E's been trying to get the Fire Victims Trust to pay even their criminal penalties. But the Fire Victims Trust does include business claims and claims for a number of governmental entities and school districts and water companies that are not part of the public entity settlement. The trust will be managed by an independent trustee, John Trotter, who everyone seems to think is highly qualified and wonderful to work with. So I'm very happy about that. PG&E and the subro, none of them have any control over the trust or the trustee or payments. And if there's any money left over, which I doubt there will be, it does not go back to PG&E. Everything will go to fire victims, or if fire victims get paid, there'll be some going to FEMA. What we don't know yet are the procedures for providing information to the trustee, or how the information will be evaluated, or how distributions and payments will be made. All that's being worked on. I know that a lot of the attorneys that represent us have been on committees working on these kind of guidelines, but that information is not public yet. So let's look at the next slide. Okay, so now I'm going to get into a little more detail about funding the Fire Victims Trust. So I mentioned on the effective date, PG&E will put $5.4 billion in cash into the Fire Victims Trust. And some of you have heard of these, the term backstop agreements, equity backstop agreements. Those agreements help provide some support so PG&E will know it will have the money to meet some of these initial obligations on the effective date, including putting the $5.4 billion into the Fire Victims Trust. Then there'll be the two deferred payments that I mentioned earlier, January of 21 and January of 22. That will be cash that's generated because PG&E will be able to take a deduction for tax purposes, and it's going to save some cash by not having to pay taxes, and that will come into the Fire Victims Trust. These obligations are backed by letters of credit and stipulated judgments. I'm not an expert on those kind of collateral, but it looks fairly solid to me. I think if PG&E were to file bankruptcy again, it would delay these payments maybe by a couple of years, but I do think we will eventually see them. So then now let's go to the next slide and we'll look at more about the stock. Okay. This is where, to get into a little bit of Alice in Wonderland area. So we're being told we're getting 6.75 billion in common stock of the new PG&E Corporation. But it's not 6.75 based upon the fair market value of the stock. There's this term used in pricing stock called a PE ratio, which is the price earning ratio. And the way to think about that is if a stock has earnings of $1 per share, and it's trading at a PE ratio of 10, then each share is going to cost $10. So it's the earnings times 10. And a stock that's trading at a PE ratio of 30 would be selling for $30 a share. And a lot of that is what the market determines is the upside potential of the stock. That has a lot to do with what its PE ratio is. So in the settlement agreement, what's shorthand called the RSA, the TCC, the Tort Claims Committee that represents us, agreed that our stock would be priced as if it were selling at a PE ratio of 14.9. I am not going to opine one way or another whether that was the right number in December of 2019. But now in April 2020, it's a whole new world. Coronavirus has brought the market way down, and the PE ratios of comparable utilities have come down, although I understand not as much as some other stocks. So one analyst in a recent filing said that at current market value, our stock would be worth something around 4.8 billion instead of 6.75 billion. And one of the big arguments that's still going on is whether PG&E promised us 6.75 billion at fair market value or 6.75 billion assuming a PE ratio of 14.9. That's a question that's now before the court, and I can't answer it. But it is important to know that the backstop parties, if they have to come forward and buy the stock, they're going to be paying for it at a PE ratio of between 9 or 10. So quite a bit less than what we are paying for it. And the other thing that everyone needs to realize is the value of the stock may go up or down. There have been some talk about the value of the stock being guaranteed or insured. It's not. It's going to float with the market. There's going to be some adjustment that if the price has gone down, we may end up getting a larger share of the company. I've heard estimates that we may end up getting the trust, may end up getting 25% of PG&E common stock. And just as one last point, that stock will be held by the trust. And it will be sold to pay cash to individual fire victims. Some lawyers have talked about whether they might take some stock for fees, and individuals have asked about it, but I have no idea where that will all end up. That's going to be something worked out by the trustee. So let's go to the next slide. Okay. Just to add another layer of complication to the stock, when someone owns 25% of a company, you can't sell that stock right away, and you can't sell that stock very quickly without really tanking the price. So what's assumed will happen is that the stock or the trustee will have to enter into a registration rights or sometimes called a shareholders rights agreement, where this stock might be locked up for 180 days or longer or shorter before it can sell any stock. And then it may have limits on how much stock it can sell per month or some other period. So it's important to understand that it could take 1 or even 2 fire seasons to sell off the stock. And during that time, the stock could go up and down in value. I know the TCC is negotiating or trying to negotiate with PG&E that it wants to make sure that if the trust stock is locked up, that the hedge funds and the backstop parties, that their stock is locked up in a comparable way. That would seem to be fair. And we don't want the hedge funds to go out and sell all their stock right away and perhaps reduce the value of the stock in the trust. So let's look at the next slide. Oh, now we get to the stressful part. PG&E doesn't have all the money in hand right now. It has to raise this money. And that's part of all the plan is how it's going to raise the money. It's going to be issuing common stock to the market in a stock offering. And if that doesn't work, that's when the backstop parties step in and buy it. They're converting some debt into equity. That's actually what's happening to fire victims. You turn debt of the company into an ownership interest in the company. It's a common practice, although it doesn't usually happen to the involuntary creditors like fire victims. And PG&E is taking out more loans, it's restructuring and refinancing its loans, it's converting some loans from unsecured loans to secured loans. It's, as I said, this is a very large and complex business transaction. And here are some of the places the money will be going to. It will be going, there's a whole list of here of where the initial funds are going. And so as you can see, that's a lot of money moving through the company very quickly. So let's look at the next slide. So part of the backing or the support that's going to get PG&E out of bankruptcy are these backstop and debt commitment agreements. These are great to have. We wouldn't want to vote on a plan without them. They are expensive, but they're there. But from what I understand, PG&E is still short about $6 billion. And PG&E has been stating in court documents that it never promised that the effective date would be by August. And it may be the effective date will be in December. Now, that is, when I talked about stress, that creates some stress for everybody, because a lot of this was structured assuming that the effective date would be no later than August 29th. So a number of parties, including the backstop commitment parties, can back out of the deal if it's not funded by August 29th. And if some of you have listened to Michael Watt's talks, he has said that if the trust isn't funded by August 29th, we can walk. I always want to say, where are we going to walk to? This is not going to be a great situation to be in. And if worse comes to worse and PG&E can't fund by the end of this year, then under an agreement they've come to with Governor Newsom, the company will be put up for sale, and the sale is expected to close by September 30 of next year. So all this means is, even if we adopt this plan and vote for this plan, there are some risks that we will end up really as if we never had a plan, and the company will get sold, but instead of being in 2020, it will be in 2021. So let's look at the next slide. So I'm just going to quickly go back to look at the open issues. These are some of the issues that the TCC is still working on, and all of our attorneys are very active in. The issues of delaying the effective date, and how, among other things, it could make the deal fall apart, but it would also delay payments to fire victims. The issue of how do we value the stock in the fire that's going into the fire victims trust? Is it 6.75 in market value, or 6.75 based upon a PE ratio of 14.9? When can the trust sell the stock? Again, the trust can't pay fire victims in full till it is able, or at all, or it can't. There's going to be a lot of payments are going to be delayed if the trust can't sell the stock. Fundamentally, and this is my biggest issue with the plan, and I'll be candid about this, in business transactions, we generally try to allocate risk of the what ifs to the parties who are compensated to take that risk. And that's generally going to be insurance companies or investors. In this case, the risk of future fires and delay, well, mostly future fires, is going onto the victims. That is one of the injustices of this plan, but it's one of the realities as well. At this point, and during this period when we're voting, we don't know what we're going to get paid, and we don't know when we're going to get paid. There's just a structure for determining the process, but we don't have how that mechanism is going to work yet. And PG&E has been very clear. It can't guarantee that any of this will work. It's a plan, and that's all it is. It's not really a contract. I mean, we are obligated to live by it, but if PG&E can't live by it or doesn't live by it, then we really don't have a remedy. We can't sue PG&E. We just pretty much have to, we retain our rights and our claims, and we have to wait for the company to be sold. So let's look at the next slide. Oh, so we get to the biggest open issue is the longer that the deal is delayed, and the effective date is delayed, the bigger the risk of another major fire. If there's a major fire, the backstop parties can pull out if more than 500 structures are affected. This is a fire that's in a PG&E area that hasn't been depowered. If there's a fire, the stock price will drop. And then if there is a major fire, the claims of other fire victims would come before us. So, what are our options? Unfortunately, we probably don't have any other options. I mean, there's certainly talk about possible other plans, community-owned utilities, state-owned utilities. There probably are, I would guess, buyers for PG&E. I mean, it is a monopoly providing power to, I think, 20 million Californians. It definitely has some liabilities and expenses to work its way through, but it should eventually be a very attractive investment. But if those plans are out there, we as fire victims know very little about them. So it really comes down to a leap of faith, one way or another. With the current plan, it's a leap of faith, and there is some description about where we're likely to land or where we will hopefully land. And without a plan, it's a leap of faith, and we don't know. And I can't say which is the right way to go for anybody. That's really going to be an individual decision. So what's next? Let's look at the next slide. Oh, how dramatic here. Okay, so now you should all be getting, if you haven't gotten it yet, by email or by mail, the disclosure statement, copy of the plan, your ballot. I think Prime Clerk's been very slow getting them out. Some attorneys have delivered them or made them available by text or by email, but they were worked on for our benefit to review. I encourage you to take a look at them, at least read through the headings, read the sections that are important to you. You should have consultations with your attorneys. This is what they're there for, to advise, to analyze, to explain. There will be town halls by various different attorneys. That's what I urge you to ask your attorneys questions. There's no stupid question. We are now in the process of voting to approve or disapprove the plan. The TCC has requested that everyone hold their votes till May 1st so they can try to narrow the open issues. But again, that's an individual choice. You have until 4 p.m. on May 15th to vote. But make sure it's your vote and you really take the time you need to make an informed vote. So let's look at the next slide. Okay. This is a picture of some of the odds and ends of pottery I found when we went through our ashes. Okay, so the vote, the plan must be approved by more than 1/2 in number and 2/3 in value of those voting to be considered approved. For the purposes of voting, all of our claims are valued at $1. That was a compromise hammered out, as I understand, because on one hand, you've got large business claims that are voting, and we didn't want, what the TCC didn't want them to dominate. On the other hand, there are a lot of claims out there that may be for just ash or smoke damage, and they have as much of a vote as people who lost their home. And Judge Montali has the power legally to approve the plan, even if we don't approve it by vote. He has said he's not inclined to do that, but he does still have that power. So the next, I'm going now to the last slide, which is where to learn more. The first place to go to learn more is your attorney. You can also go to Prime Clerk and read a lot of the court filings. Some of them are organized. There's a left-hand margin where you can click onto a more narrow selection of information. You can also look at, of course, look at the disclosure materials that were sent to you. These are now 2 sites, PG&E fireinfo.com and firesurvivorsvotes.com. I think actually it's vote singular, that's my mistake there. Those are both put together by volunteers with some information. Again, that's going to be information like what I'm presenting here. It's officially unofficial. So, but we're trying to just provide information that we can. Now that's going to wrap up my slides, and that's me there taking a picture of what used to be our house, and it's hard to look at. So Jason, you can wrap up the slides now. We can come back and start answering questions.
Okay, great. And thank you, Helen. It's very helpful to have the presentation alongside. I apologize for the technical difficulties. We are going to look to make it available so people will have that in addition to the video. I think it's good to have your commentary as it's walked through. So it's helpful to have the video, even if there is some difficulties in reading some of the slides, but we will make the slides available too. So I do have some questions that have been shared, submitted earlier through our website, firesurvivorsvote.com, and some additional questions that have come in the course of the presentation through the chat feature. I'll go back and forth with various questions. Again, the ones that were submitted online, unless you gave us permission or specifically indicated to use your name, we won't give any attribution. The ones that have come through the chat feed, I may give attribution there, just given it's already public and how that's working, just to show that it is an interactive environment. So Helen, starting with one of the questions that we had from the submissions, what happened to the made whole doctrine, and why are the subros not inferior to our claims? Can you speak a little bit more about those issues?
Yeah, that I'm going to have to step back and talk about the made whole doctrine. In California law, and I talked about subrogation rights, where the insurance company has the right to go after PG&E for amounts that claim for you. Generally, sorry, my husband's calling the dog here, is distracting me. This is the life under coronavirus. Under the made whole doctrine, I mean, I'm not sure getting this completely correct, but generally, if you have a recovery from PG&E, it's a double recovery, or potentially a double recovery from what you received from the insurance company would try to get that from you. But under the made whole doctrine, you're entitled to recover from PG&E for all your uninsured losses, your lost trees, your emotional distress, your physical injuries, your lost income. It's a bigger category that you can recover from before your insurance company can recover. But under the bankruptcy plan, the insurance companies are getting paid $11 billion, even though, and they're getting it in cash right away, and we're having to wait. So they're getting paid probably a better deal than we are sooner. And because it's obviously making people nervous, the current obligation is that as a condition to receiving payments from the Fire Victims Trust, we are each of us going to have to sign a made whole release. So if there's any claims that we were entitled to get paid before our insurance companies, we are going to have to waive those. That's an attachment to the bankruptcy plan. I think it's Exhibit C. My understanding was what the insurance companies wanted an even broader release than that, but it was hammered down to a made whole release. It does not release any claims people might have to get their insurance to pay them, for underinsurance, for bad faith. It's merely a release of the make whole doctrine. Hopefully that's made some sense.
Thank you, Helen. Moving on to another question. Why are we only able to learn and vote on this one plan? I understand that there were 3. Please explain the exclusivity that PG&E was granted.
This is part of the bankruptcy structure that tends to favor the debtor. The debtor gets the first chance, the second chance, the third chance to present a plan. And PG&E did. And at this point, it still has the exclusive right to present a plan. And under the various settlement agreements, the RSAs with parties, they obligated our attorneys and the TCC to support this plan. So there hasn't been an opening for other plans to be presented to us, or to really even negotiate with the TCC and our attorneys. There may be interest out there, but they've been blocked from coming forward. If PG&E ends up not being able to raise the funds and the effective date doesn't happen, at some point, and I believe it's in September, their exclusivity period will end. And it could be that other plans come forward. But that's again, it's not PG&E's doing, it's really a part of the whole bankruptcy structure.
Okay, and moving on to another question. Please explain what the TCC is, why they matter to us, and what their position on this plan has been and is now.
Oh, multiple questions. The TCC is short for the Tort Claims Committee. That is a group of what had been 11 is now 8 people who represent tort claimants. Torts are people for bodily injury generally, or some kind of injury or loss, non-contractual. So those 11 members represent all tort claimants. And then that committee hires its own set of attorneys that is paid by PG&E, that is supposed to be representing all fire victims. Most of us have our own attorneys that are representing us in our action, but they are personal injury attorneys generally. Baker Hosteller, the attorneys for the TCC, are the bankruptcy experts. I believe many of our attorneys have become bankruptcy experts through this process. Now, there may have been multiple parts of that question I didn't get to.
Yes, so please explain what the TCC is, why they matter to us, and what their position on this plan has been and is now.
That's the key thing. The TCC, under the RSA, which is the settlement agreement that was entered into last September, it was obligated to support this plan. There's a big fight going on. TCC is alleging that PG&E has breached that RSA, that settlement agreement, by delaying the effective date, by the way they're valuing the stock, and because they're taking on more debt and issuing less equity than was expected. And for that reason, the TCC is not, at this point, supporting the plan. And of course, PG&E is arguing that the TCC is breaching the RSA, this must make you crazy, by not supporting the plan. It's one of the reasons why we need to wait to vote. Yeah.
Yes. Another question here. Some attorneys are claiming that the 13.5 billion will pay 90 to 100 cents on the dollar for the fire victims' claims. How is this figure determined to pay all the claims from so many fires, since most claim amounts, not to mention pain and suffering, are undetermined?
That's a really good question. I can only tell you what I've heard, and I don't have any direct knowledge. What I've heard is that 13.5 billion, if we were indeed getting 13.5 billion, or do get it, will probably cover 90% of property damage. I think there have been some rough calculations about what that could be, but it won't cover pain and suffering, wrongful death, loss of income, attorney's fees, interest, punitive damages. Once you add some of those things in, it won't be 90%. Now, this is probably fifth-hand knowledge, so this is a question to ask your attorney.
I might also add there too that originally there had been an estimation trial that was scheduled whereby a court would be listening to testimony from both experts as well as victims who lost their homes and livelihoods in the fire. And through that information, there would have been an appraisal, in effect, or an appraisal either of criteria or other factors to get a better idea of how the total claim should be valued. And as a result of the settlement that occurred back in December, that trial was originally postponed and then effectively canceled by virtue of there being a settlement amount. So once the amount was set at 13.5 billion as a total dollar amount, regardless of how it got paid, there was no need to go forward with an estimation trial on what the damages should be. So to my knowledge, at least in the context of the discussion so far, there hadn't been a full explanation, say, or insight into the different positions of victims, the nature of the claims that they had. We have the claims that have been filed as part of the large database. It's publicly available. You can see the names of people, and a lot of people are still claiming $0 damage, which is fine to do at this point in the process. You'll be able to give information at a later date, but we didn't really get into a lot of the details as to the differences or the distinctions of the kinds of losses that people had that might have otherwise come forward in the estimation trial. So. Moving into another area here, but related to this $13.5 billion total, Helen, are the attorney's fees subtracted from the $13.5 billion? And after those fees are paid, then understanding is the victims would be left with whatever is, first we'll have the top dollar, the attorneys then get their percentage. And I guess there's some commentary from various questions and ask questions about what's a typical fee for lawyers. And I know we have a lot of variation there. I've seen as low as maybe 20%, as high as 40%, with a lot of space in between, depending on the lawyers involved. But in terms of the general process, once the 13.5 is allocated, so to speak, would the lawyers take off the top, and then would there be other parties who would receive other fees as part of the residual before we get to what's net to the fire victims?
This is how it usually works, is the trustee will determine, will work with a fire claimant and it'll determine what you're getting paid. And let's just say hypothetically it's $100,000. Covering all the claims, and maybe that's 50 cents on the dollar, maybe it's 80 cents on the dollar, I don't know. Usually that money is sent to the attorney's trust account. Generally, let's say that it comes in 2 installments. You get one first payment of $50,000. Generally, the attorney will take their percentage out of that amount. Like if their percentage is 20%, they would take 20% out of that $50,000. And if they had some costs that were specific to your claim, like they had an arborist go out, or they had a psychological profile done or something, they would deduct a percentage of those, and then they'd send you the rest. So each time a payment came in, it will get paid. The trustee isn't not like off the top just going to pay 33% to the whole pool of attorneys. It's going to, as the payments come out and go through the attorney's trust account, that's when attorneys will get paid. If you don't have an attorney, the payments will come directly to you. And then what's a fair amount? It does range. Actually, I'm not going to touch that one. I'm going to let people talk to their attorneys about what they think a fair compensation should be.
Okay. Yeah. And I guess related a bit to this question of the distribution of the funds, and you've talked a little bit, Helen, already about it, that we don't really have a lot of insight right now into how much any of us are going to be able to receive as part of our claims at this point in the process. So I'm wondering if you could maybe just speak a little bit more into the question, why should a victim vote yes when they don't know their specific recovery amount? Also, given all the forums that have been out there, town halls and otherwise, there haven't been a lot of indications for any particular family or claimant as to what their claim is actually worth. And that's a part of the process, but perhaps you can address some of those concerns that people have. How do I say yes to something when I don't know what I'm actually going to get? All we're really knowing is what the aggregate amount is.
It's the leap of faith problem. We don't know. And at the pace this bankruptcy is going, because of AB 1054, we won't know. It's going to be a process. It's a lot of information. If you think about 70,000 to 80,000 claims, each one needs to be evaluated, supported. We won't know. It's an unusual circumstance to be in, but I don't think it's going to change. And if there were a different plan going at this pace, it would probably be the same thing.
Mm-hmm. Yeah. A couple of questions in the chat feed. One from Sherry Bagley. Has anyone said how much PG&E is actually worth if it had to be sold off? Would this be better for the fire claimants? There have been quite a few threads in this arena, like around the alternatives. What's the value? How do we really understand what other options we have?
I've heard various numbers of value, and I can't come up with them off the top of my head, but let's say it's worth 60 billion or 80 billion. Yes, it could happen. It would probably take longer. It could take longer. As I said, the timing on when we're getting paid under this plan is not solid, but it's certainly further along than selling the company. I would love to have the answer to that one. I don't. Yeah. It's a good question.
Yes. There have been a couple questions too, just talking about some of the uncertainties with respect to PG&E. Like today, there was a report, I understand, that the CEO has indicated that he would step down or resign in the next couple of months. And there have been a few questions in the chat space and otherwise asking about how that could potentially affect the deal. If the CEO leaves, would that potentially mean that the deal would no longer be viable? Would a new interim CEO be required to honor what's been in effect so far? Again, we're looking at some things in the hypothetical arena, but at least it shows people are concerned about what the changes in administration or management, how that will potentially affect our deal.
I have no idea why he resigned, but I don't think it will affect the deal because we're not really negotiating with management. We're negotiating with the major shareholders and the board of directors, and maybe he's left because part of Governor Newsom's plan to change the ownership of the company, he knew his days were numbered anyway. That's total speculation. I don't know. I wish I were the fly on the wall to hear the reasons why. PG&E has had unstable management and some bad management decisions made over the decades. It would take a brave CEO to go in there and turn it around. And I imagine I hope we get a brave and a smart and a good one next.
Touching again also, Helen, into the claims issue and what's coming out of the wildfire trust pool. Have the claims for FEMA and CAL FIRE been removed from the victims' trust? Why are fire victims being held accountable for the administration costs of the fund that's being forced on them as part of the settlement?
FEMA's not been moved out of the trust. There are details about that, which I probably have here somewhere. Do very quickly. FEMA's, they reduced their claim to $1 billion, and they'll only get paid if all of us get 100%. Other federal claims reduced to 117 million, and they're paid from any third-party recoveries from the tree trimmers in that category. Cal OES, 115 million, paid on interest earned in the trust. And other claims will be paid on any gain on the stock, other state claims, above 6.75 billion. So mostly those have been greatly reduced and impact hopefully minimized. And then the second part of that question was,
why are fire victims being held accountable for the administration costs of the fund that's being forced on them as part of the settlement?
That one I probably blanked on because I don't have an answer. That may be fairly typical, but we are paying for it, and it will be hundreds of millions, I would guess. It's a lot of claims to process and a lot of expensive people.
And let me just hear, I've got maybe I think 3 or 4 more questions left, and I'll again go back over to the chat space and see how things are going. So there's a bit of a lag between our presentation and how it's being displayed through the live stream. So if you have any additional questions that you'd like to add in the chat space, this would be a good time to be able to do that. And then I can check it after I go through these next couple of questions. Asked by Stephen Mooser, is there any point in writing to Judge Montali at this point to express our concerns or suggestions regarding the plan?
You have every right to write Montali, Judge Donato, Gavin Newsom, express your thoughts, be respectful. Perhaps if you have any rapport with your attorney, discuss those issues with your attorney before you write the judge, because it may embarrass your attorney that you're not talking to him or her first. But I'm not going to discourage people from doing that. They should feel.
Just by way of an aside, too, with respect to submitting to Judge Montali, his clerk of the court will be in touch to the degree that you have certain personal information that you might disclose there. So it's good practice, say, to mention if you want to put your name and maybe the city or the town where you lost your home. But remember that some of these will be ultimately put onto the court docket, and you have a choice, I believe, as to whether you want that to happen. But if you have personal information, you might want to not make it personally identifying in terms of where you live or so forth. Yeah.
I think it's valuable for the judges and the governor to keep hearing from fire victims. We tend to get lost in the process. As I said, the process isn't really structured for fire victims. People should know that we have been very unusual in that we haven't kind of just laid down and died and taken what's been given to us. We really kicked up a fuss, and thank you to everybody who's doing that.
Yeah. And one of the points that came from our forum last week, I think, was the uniqueness of this particular bankruptcy. And there's been several articles in the press writing about how different it is to have victims or creditors in this context actually gathering together and utilizing social media and the power of their numbers to influence potentially what's going on at the table in the negotiation. So that's been a unique aspect here. I wanted to mention a couple of things too on there's a couple questions here around information and the disclosure statement. Richard Beyer had asked a question as to whether or not the information we have had, is it deemed to be adequate for purposes of bankruptcy law? There's certain obligations under bankruptcy law that were given proper adequate disclosure. I know there have been some filings as to whether or not the disclosure statement should be updated or further revised. Can you speak to maybe this question of sufficiency of information?
The judge will have to make that. The judge so far has felt that the information is adequate, and he's approved it. But you're right, not everybody agrees with that, but ultimately it's going to be up to Judge Montali to make that call. Yeah.
See, bear with me a second here. Let's see, a question from William Hansen in the chat. If a claimant or a claim is actually paid, then will that claimant need to sign some kind of non-disclosure agreement as part of the settlement?
I've never heard anything about a non-disclosure agreement. You will be, as part of releasing all your claims against PG&E relating to the fire, and you will be signing a made whole release against your insurance company for any made whole claims, not any other claims. But I'm not aware. People may want it to be. I would think the trustee would be under an obligation to keep it private. I just don't know how much has to be reported back to the court.
Yes.
Maybe none at all because it's in the trust. Yeah.
Also, I'm reminded that in the context of the liability trial around the Tubbs fire, that there had been some settlement there that has been under redaction in the court documents. It's under seal in terms of what the aggregate amount is and what the individual plaintiffs in that case had agreed to settle for. Yeah, so there had been a potential trial in the liability issue around Tubbs for a certain subgroup of plaintiffs who were deemed more vulnerable and had special rights under California law to assert their claims in a more quick fashion. And as a result, of the settlement, there had been, in the larger bankruptcy, there was also a settlement on the Tubbs liability issue for this particular trial that doesn't apply to all Tubbs victims, that only applies to that group of people. And the aggregate amount that was settled for them is subject to non-disclosure, I guess, at this point. And we're not sure how that could potentially influence the way that claims are allocated to people who were part of the Tubbs fire, but not part of that lawsuit. But at least there is some precedent for some non-disclosure, but the context was different. So I wanted to mention that.
One good thing to mention is PG&E originally wanted to be in control of the trust, which meant each of us would have had to keep fighting with PG&E as we process our claim all along the way. And PG&E would have had an incentive to just make it really hard. Our attorneys collectively really fought that and succeeded in getting a independent third party with an excellent reputation who will, and a team of people who will be doing the work on evaluating our claims. And PG&E will have no say in how the trust is administered, which is a really nice thing.
Can you say more? There was a question as well about the validity of claims. So some people are concerned in seeing that there are reports, at least, of multiple claims from certain parties or invalid claims. And how does that dilute potentially the total amount that's being divided?
From what I've read in the disclosure statement, they've already eliminated 4,000 claims as either being out of the fire area. Who knows what they were. And I'm sure they're continuing to eliminate claims. They'll go for the low hanging fruit first, people who live in Chicago or, or someplace far away, Vallejo, and then they'll weed out duplicate claims. There were a lot of those because I know at least one law firm that submitted both online and by mail. So, there are probably 5,000 duplicates right there. They are going to look at, from what I understand, they're looking at each claim and they're evaluating them. And of course, the first place you start is how valid is this claim? For voting purposes, they haven't gotten very far. So there will be some people who are voting who probably shouldn't be. But again, this is, I think, a result of this being on a fast track.
Yeah. Questions coming in online on the chat space. Richard Byer, how can we legally relinquish our rights when we have not been made whole? We're forced to agree to waive our rights as if we were made whole. So there's this that aspect of the release that you were just talking about.
It's been sanitized. It gets basically, yes, you are compromising, and that's what the law process does. And it's being sanitized by the bankruptcy process and the documents you sign. That is part of the package and probably would be part of the package in any plan. I'm not saying this plan is worse than any other that way. Anytime you have litigation in which there are unknowns and negotiations, people end up with a compromise. Yeah.
Also, there have been a couple of questions you touched on a little bit already, Helen, around the claims process itself and maybe establishing our claims. There have been some specific questions as to what might people want to be preparing at this point in order to coordinate with their lawyers. Assuming this were to go forward and there is a resolution and a yes vote for the plan and the plan is adopted, then we'll move into the process of claims administration, and there would be a need from the victims to coordinate with their legal counsel or potentially through the trust on their own if they choose not to be represented, what their claims have been. Maybe you could speak a little bit to the kinds of things people might want to be thinking about at this point as they kind of monitor the vote and anticipate needing to provide proof of their claims.
Okay, a lot of this you should be talking to your attorney. This is part of what your attorney gets their contingency fee for, is helping you prepare and support your claim. But I'm sure it's a lot of it's the same kind of material. If you had insurance, you provide it to your insurance company. Any photos you had of your home or anything you owned, medical reports if you have a personal injury, a narrative of the night, receipts for what you've replaced. If you had a business, prior tax returns, any financial statements for your business going back. If you have lost trees, you could hire an arborist if you don't have an attorney, or your attorney would hire an arborist as one of the expenses that they deduct when you get a award. A lot of people lost hundreds of trees, and so it's the cost of both how it diminishes the value of your property and the cost of removal. So keep every receipt. What I advised to people after the campfire when they had no place to put their receipts was take pictures of them. It's an easier way than keeping tracks of a lot of slips of paper. So it's more paperwork.
And in terms of inventory of personal contents, I was just, as we were asking this question, I was reflecting that a few other fire victims have told me that they've been suggested to go through their lists, and maybe they prepared one for insurance companies. Maybe they want to go back through now and just make special notice of certain things that were special notations of certain things that might have had greater sentimental value than their actual financial cost. Things like that, just to be able to quantify a little bit more what's unique about the things that you had. Like, more likely everybody has a television, but you might not have still your wedding dress, or you might not have other things that have been handed down that might have specific value to you, emotional value that you'd like to be able to recognize. And so there may be some value individually for us just to go through. It's hard to go back and look at those lists again and try to revisit what you've had, and even worse after time's passed. But if there are specific heirlooms that were part of, maybe you lost vintage vehicles or something, to put some more detail about those things together for your insurance company, or from your insurance company records for purposes of the trust administration.
And there are attorneys that are really helping that way, hiring public adjusters and helping with the inventory, because certainly the personal property inventory is a very painful part of the process, because you just have to relive losing all those things again. Yeah. So reach out for help on that.
Yes. Bear with me a minute while I just look through here and see. James Robertson writes in the chat, what happens to PG&E if we vote no and the judge agrees with us? What happens to us under that circumstance?
PG&E, this is my guess. I have no crystal ball on predicting the future, but my guess is PG&E will scramble to put together Plan B. If they're smart, they probably already have Plan B pretty ready to go. If they're nervous at all about the vote. And there is enough gravy in this that in this plan, there are people making a profit. I think it's the hedge funds are making profits. There is enough money still in this plan that if they shuffled things around, they might move some of the risk off fire victims and put it where it belongs, which is on insurance companies or investors. So it would be a scramble. And what I understand PG&E can do is it can hold on to the yes votes, scramble, go back to the no voters, say, here's the changes we made to the plan. You want to change your vote? They can, I understand they can do that after May 15th. I'm not an expert. That's what I've heard talking to a bankruptcy attorney. So it's not the end of the world. I don't think it's the end of the world. I think there'll be a scramble and Plan B will suddenly appear.
Marisol Richardson writes, if our attorney has had to sign a contract, but yet haven't worked into the process of some of the details of this just yet, is there a possibility to change attorneys? I guess at what point are we somewhat locked in with the counsel that we have versus being able to potentially change?
This is a tough one. You know, you're pretty deep in the process for changing attorneys, but you always have the right. You always have the right to terminate an attorney, particularly if you don't trust them or they don't communicate well, you never hear from them. You always have that right. Getting a new attorney may be more complicated at this point. There may be fee sharing to deal with. So I'm saying it can be done. The longer you wait, the more complicated it is because there are more entanglements. And before you would do that, I would just try to have a heart-to-heart with your attorney and see if you can work things out, because it's not so easy at this point.
I would echo that. You know, try to bring up questions around or concerns that you might have about communication, or because there's a variety of lawyers who are involved in this process. You know, there's some people who've been active at the table negotiations. There are some lawyers who are less involved at that process, but they'll be more involved in helping you go through your particular claim and making the filings on your behalf with the administrators of the trust. And so it's important to have a good relationship. You'll have to work closely with them in going through the claims process. But as Helen pointed out, there typically are provisions in the engagement letters with lawyers that would indicate some kind of fee sharing. So if you leave at a certain point in time, that those lawyers that have represented you already could potentially make claims still on a portion of the money that you're receiving based upon the work that they've done to date. And that can get a little bit difficult sometimes in trying to figure out who's supposed to get what. So your retention agreement is the place to understand that, or your engagement letter with your lawyer. But as Helen points out, keeping that open communication with your lawyer about areas where you might be dissatisfied or want more communication, that can also help them understand, you know, you're probably not the only one among their clients that are having those concerns, and maybe there's a wider outreach that can be done. You know, we've seen a variety of lawyers and law firms be very proactive in sharing information with their clients about the cases. Others have been less so. I think some of that is perhaps some law firms are more at the table. Some law firms are further away. Some are in the point of view still that it's good to wait a little longer and let's see what ultimately comes out. You know, we've heard lawyers say yes to the deal, no to the deal, or recommend yes, no, or wait. There's a lot of variation still. And so as we get a little closer to, I guess, May 1st and those few days afterwards, we should have a better picture as to how even those law firms that have been suggesting to wait, how they would recommend we vote.
It's a tough question at this point.
Let's see, bear with me here. Yeah, I guess there was a question here. If insurance companies, from Sherry Bagley, if insurance companies get paid for what they paid us, do we get the money back that we have paid to the insurance company for all those years, our premiums? You know, I guess, yeah, you want to talk a little bit about that aspect?
No, the short answer is no.
Yeah, sadly, no, that's part of their profit in a sense, right?
Yeah.
Is there a way to know which attorneys are working on the committee right now, or the various, like who's at the table? Do we know who's ongoing in the discussions, or is that available?
Yes, but I would ask your attorney. That would be the fastest way to get that information. There was recently a filing where it was the US trustee did a filing that talked about how the membership of the TCC had changed. I don't know whether it has so that would be an individual, and that individual is represented by an attorney, and really both are, in a sense, on the TCC in terms of a negotiating role. Talk to your attorney if you can, otherwise it would take a little research. And then in terms of who's actually doing the active negotiation, I would also talk to your attorney. I don't have transparency. I have some guesses, and I'm not going to make them out loud. There are probably about 15 firms that are working very hard on the bankruptcy process in this case. And there are supposedly 70 law firms that are involved, so that there are probably 50 or 60 that are not doing very much. On the bankruptcy side, they may be doing quite a bit to help their clients prepare their claims.
And there have been a couple of comments in the chat today dealing with, say, differences or disparities between those who lost their homes in the Camp Fire versus those who lost them in the North Bay fires, somewhat the differences among fire victims and how that potentially might impact the ways that we're viewing the yes or no vote. And in particular, also, there have been some questions or asking like, gosh, there's nobody here on this panel, at least between you and I, we're both North Bay fire victims, so we're not in the Camp Fire situation to understand maybe what's on the ground there. And I guess I wanted at least to mention that, you know, our group of 7 of the who sort of initially started this, and we have outreach from there into a variety of communities. We've all come together sort of as volunteers. Some of us were related to the Camp Fire, the other fires that happened in 2018, some going back to 17. And really, we just come together to try to prepare and offer information and outreach as best we can into different groups. And it just happened that for today's session, given the scope of it being more nuts and bolts and trying to understand better the details of the documents, you know, both Helen and I have been trained as lawyers and worked as transactional lawyers. We're not litigators, we're not bankruptcy lawyers, we're not representing anybody in these cases right now. Really, we don't have clients. We're just here going through this as fire victims. And given our experience with some of the deal terms and understanding the context, after the last forum, we thought there's a need here for people just to get more information on the nuts and bolts of the deal. Really, Helen brought that to bear because we have a lot of lawyers offering their perspectives on certain things, but to just really hear a little bit more of a balanced view. So we wanted to create something from that point of view. I don't know if you want to say something, Helen, to the aspect of, you know, fire versus
the bankruptcy process threw us all in together. And we're all in the same, you know, we aren't quantified or qualified in any way. But people who lived in Paradise had a whole nother level of trauma and loss. Jason, I know you had a harrowing escape, but that's going to be multiplied 10,000 times up in Paradise. So I think that when you look at it on a case-by-case basis, everybody is different, and that will be taken into account. But in terms of voting and how we're treated as a class in the bankruptcy case, we're all in this together. It also helps, you know, we are a year further away from the fire, and you know, it does get better. You do get more your feet back under you. So I think having that extra year, we're better able to help guide others.
Yeah. There's a little bit more distance, and maybe we've made more progress in terms of our insurance claims and other issues. Like in terms of, like you said, we had a very harrowing escape. I had no notice that night when it happened. I got out with my elderly parents at 2 in the morning, and we drove, much like many people from the Camp Fire situation, drove through the fire, literally in the mouth of the dragon. And we had obstacles at every turn. My car was completely totaled with a broken axle, cracked subframe. The level of damage was amazing. And we think that we actually survived that. But we've had a little bit more time, and yet many things are still very stagnant. My property is still up there waiting to be remediated from the work that FEMA did and botched up. And I'm still trying to get my insurance company to pay pay the county for what the county is administering as part of the FEMA program. So there's a lot of ambiguity still as to when all this is going to be finished. And I'm, like you, Helen, more than 30 months into this process. But I think, like you said, we've all been put into this bankruptcy process as co-creditors, and we're all kind of standing shoulder to shoulder here. But I think we also have to call out and recognize that there are a lot of differences in different individuals. Like some people, my father and others, have had health issues, and right before the fire, they may not have, they were having illnesses or other things they had to deal with. So this fire met them there. And subsequently, some people I know from the policyholder groups that we had formed locally, some of the older people have passed away from injuries they had or from a lot of the stress and trauma from that situation. And so the fire is an equalizer in that it meets us exactly where we are in that particular day, whether we're old or young or disabled or healthy or employed or unemployed. It's going to meet us there. And frankly, the unraveling that happens also comes from there. And each one of us has our unique story as to how we've borne that challenge and the suffering that's come with us. But I guess I have felt so far in this process how it's so important that we come together. And as I've struggled in my process with insurance and looking to get through my own grief and figure out what to do in light of these big systems that I'm having to face, I felt like it was important to reach out to other fire victims, other people who like me went through this, and other people, say, particularly who had a legal background that I could coordinate with and say, how can we help make sense of this better, not just for ourselves, but for other people? Let's use what we have, whatever resources and privilege we have, to try to serve the common good as best we can, recognizing that we're still human and we're going through a lot of stuff on a daily basis. I've had to move. This is my 18th time in 30 months that I've moved with my elderly mother now, my father in assisted care. And it's like there's so much kind of going on personally, plus all of this. But we get strength in working against the, all of the factions that are there, helping to clarify that information. We get that strength working together. And it's not so much about yes or no, but being more fully informed. And I think that was the stance that I felt was important, that we show ourselves as being a group, and we find that through that coalescing, we can better leverage more information so we can be better informed. So I get off my soapbox, but.
What got everybody through, or it's getting everybody through, is community. Like in my neighborhood, we had a contractor, a general contractor, did lots of big bulldozers and stuff. He got up there within hours of when the fire hit, and with water trucks and bulldozers, and saved the few houses that made it. And then other people were water specialists and helped get our water system back, all volunteers. Another person used to work at the planning department, helping people with plans. As an attorney, I could help here. As doctors helped, gardeners helped. Without community, we wouldn't come together. So it's not just lawyers. Lawyers now are in the forefront, but we are just small parts of a larger community helping us recover.
And that's really, I think, been the equalizing force. Like I remember going down to where the community center was in the days after the fire and standing in line with lots of other people who lost their homes from all over the area. And Red Cross was there. There was food being doled out and other things for animals and all kinds of things that you would need for your immediate survival. But then all these meetings, all the people who came down and had their booths, and you could go from person to person to figure out what goes on with FEMA, what goes on with the permitting planning process. I mean, we were all just standing in line going through this, and it didn't matter what part of town you were in, whether you had insurance or not, what your history was. We were all, we had just a devastating loss. And I don't think any of us knew at that time all the layers and the complexity that we'd have to deal with that's ongoing. It's not something that you just go through and it finishes, or that you get yourself out of the fire, the immediate danger, and it's over, or you finish up with insurance and it's over. Like this is a really long process. It's epic in its journey. And I think even though we might not be able to understand from each other the magnitude of what people have lost and suffered, because everybody has had maybe a slightly different face of it, we do understand the texture of it. Yeah, like I can't, we've all had a touch of this, It's like a little kid can understand the concept of love as well as an older person, but the nuance, the appreciation of it is very different. but we know basically what that emotion is. We know what the loss is like. We know what the grieving is like, even if some of us have had to grieve over our relatives and others over our pets and others over the objects that we lost or the things that connected us to our ancestors. We've all touched that grief and we've all touched that suffering. And from that place, I think, we can stand together. And it's a fractal of really what's happening in the larger system. People are being thrown together in this kind of suffering at times.
So Jason, do we have any more questions?
Yes, I did want to see, sorry, just bear with me a second. Yeah, there was some questions around, let's see here. Oh, yes. Well, some question about whether we'll be doing additional presentations and platforms like this going forward. And we tried to make this an organic process. Like we saw as the votes were coming, the voting process was initiated, we could see that there were variations among the various law firms. People were wondering what to do, hearing yes, no, wait, and it was a bit confusing. And on top of that, we saw that there were changes in the resignations of certain people on the TCC. And we thought those people have made a timeliness to this decision-making process that was not there a couple of months ago. People who've been closer to the negotiation, some of them resigned in order to protest the deal. And now that we're making decisions, we're seeing variations among informed, educated parties, our lawyers, and we wanted to grow something out of that. So we started with the forum. We had that last week. You can see the fireworks, because in some ways there's a lot of lively conversation that was there. And we had that last week. It's available at firesurvivorsvote.com if you'd like to watch it still. And this will be available as a nuts and bolts series, trying to go back to some of the basics and help to explain some of the questions. But we anticipate there could be some additional updates to the structure of the deal as things are continuing to be worked out. There'll be further opportunities for us to utilize this platform to share information that we come to understand, address some questions, and continue to try to be a platform for all fire victims, neutral as to position, but just to be able to share what we're learning and create some dialogue. We do anticipate having some additional forum in the future where we could have balanced viewpoints. And one of the important features of that and what we had last week was having the different sides and having the benefit of moderators who are an esteemed journalist, Lily Jamali, and an esteemed professor of law who's been quoted regularly on the bankruptcy process, Jared Elias. Having them come and help moderate allows us to create that balance. But we also saw, in a sense, the conversation reflect what probably has been going on behind the scenes in other places. There's yeses, there's nos. That tension was a bit recreated. That's not unusual in a dialogue process for that to happen. But how do we make sense of that? How do we get closer to what we need to actually vote for this? We're going to continue to stay in touch with that question and try to provide programming or forums that speak to that for all fire victims. Did you want to add a little bit on that, Helen, too, in terms of our programming?
Yeah, if you go to the website where you came to this talk through firesurvivorsvote.com, and there's a contact page, make requests, send us questions. We're making this up as we go along. No, we are figuring out what people need, and we're figuring out what we can do to help fill that need. So tell us what you need.
Yeah. And continue to use the submission of questions, and that's a good place to add commentary and things that you would like to see come forward. There was some question, maybe just getting back to the nuts and bolts again, as to why the insurance companies ended up being prioritized over our interests. Like, how did that happen that the 11 billion is going first to those parties? That deal was announced first, it was reached first. Why were we not first?
I don't know. I have the same questions. I have theories, but I mean, no, like conspiracy theories. I don't know whether we were they had better lawyers, better negotiators. I don't know whether it's a simpler deal. I don't know whether it's a lot of the same parties who are both shareholders and subrogation holders. I suspect that's part of it, is that there were people there were the same people on both sides in many cases. But that's a good question to ask your attorney, who might have a better knowledge of what actually happened.
Yeah. Yeah, I don't think it is so clear as to how that actually evolved. But it is a significant point of question, I think, as I've seen a lot of people in the fire community wonder, why that priority, and is there anything that could be changed about it now? Like, if we're speaking out about it now, is there anything that could be changed about that settlement, or a commentary like, well, we're having stock for our trust agreement, there's cash there. I know some lawyers have said that the insurance companies agreed to take less on the dollar, and that the hope was there'd be more on the dollar by having the stock component to it. I don't know exactly how that plays out in terms of the facts. It seems a bit more interpretive because we don't know exactly what those numbers are. We certainly don't know much about the economic damage that's, well, economic plus also the pain and suffering, other things that are out there that people have experienced, the loss of life.
Yeah, on a personal level, that is what I don't like about the plan. I understand that there are going to be uncertainties, and I understand there's going to be financing and problems, and I get all of that. What I have trouble with is that the parties who are paid to take risk are getting a better deal than fire victims, and that is hard for me to accept. I mean, I'm going to have to accept it if this plan goes through, and I will accept it. But to me, it's just it's one of the injustices that I feel that as fire victims we shouldn't have to face.
There have been a couple of questions as to how we personally stand on the current plan, and I guess I want to bring it forward because people asked it. And I know you want to say something first, Helen. I'm happy to.
I'm waiting to vote. I'm hoping there'll be a few more concessions, and before I decide.
Yeah, and that's been my vote as well too. Or I mean, my perspective is to wait a little longer. I recognize, as somebody who worked in negotiation, and you did as well too, like things can change right to the last minute. And it was common in my experience of business and these types of deals where, it's down to the wire, somebody goes to the bathroom and they happen to run into the other party. And the next thing I know, there's a block that was suddenly unlocked, and suddenly there's a new thing on the deal that just came into place. So you never know how these things are coming together. And I think the fact that people are paying attention and watching is helping. And I'm not even sure I know exactly all the issues that are in play at the table or who's there. But my knowledge of these types of processes in general is that it's going to continue to go forward for a little while, and it's worth it to wait a little longer. It's hard to say kind of in assessing right now, that yes or no part. I'm still in a holding pattern, at least until after the beginning of May. So.
Yeah, I don't see any reason to vote early personally, because they're still working on the deal. Yeah.
And that information could be valuable to us, and a lot of the lawyers will provide that to us in the coming days as things are changed, hopefully. There's also been some questions about like maybe people who are still working with insurance and they don't know what their total losses are yet. That's certainly my situation. I'm not at a full picture yet. I know how much it costs to rebuild my house. I know what the insurance has given me so far. I'm still in dispute over a lot of parts of my coverage. And so I don't really have what those numbers are. How does that potentially affect the process? Or do we have to hurry up with insurance in order to get those numbers to make our claim? You want to talk a little bit about that part?
This is probably a whole nother forum on how the interface between your insurance coverage and what you recover from the trust. The trust is going to, from what I've read, the trust is expecting you to do everything you can to get as much as you can from your insurance companies. I'm also hearing rumors that the insurance companies are now giving people a harder time, in a sense, so they save more money and you have to get more money out of the trust. So there is going to be a definite conflict between getting money from your insurance company and getting money from the trust. And unfortunately, the fire victims are the ones in the middle and who have to work it out. There is language in the trust documents so far, which are pretty minimal, saying that the trustee will work with you to get as much as you can from your insurance company, and could even take an assignment of your claims against the insurance company. If the insurance company continues to give you a hard time, there may be an opportunity to basically sell your claim to the trustee, and the trustee would go after the insurance company, and the trustee might have 50 claims like this and be in a much better position to argue with the insurance companies. Bottom line is you have to keep fighting with your insurance company. Get your attorney involved if you need it. If you don't have an attorney, there are attorneys who will help you just with the insurance part. But it ain't over yet. You have to keep fighting. And no one, there are a lot of people who don't have the final dollar amount. As part of the trust process, they'll be able to, on an individual basis, to figure that out.
Yeah. And there are databases that are made available. Again, part of the publicly available information that's mentioned in the disclosure statement deals with things like insurance records. So how much money an individual claimant has received is typically disclosable or can be obtained. So they'll have at least an aggregate number to know what you've received to date. They might not necessarily know what the total value of your policy was. And so in some cases, if you find yourself particularly underinsured and you're not able to make yourself whole, then that's one path you have to look at in terms of the underinsurance issue if you're going to try to address it with your insurance company, right? So the one option is you can work with the insurance company. Maybe you go to the Department of Insurance and they can provide some leverage. There is a complaint hotline. You can provide information, and they have staff attorneys who can help facilitate dialogue with your insurance around issues like underinsurance. They keep a separate department that just handles underinsurance issues. They have another one that would help you with things like additional living expenses if you're not getting paid on time. But if you're underinsured, that's a slightly different issue than if you're just trying to claim money in your policy and having a hard time doing that with your insurance company. There you could look more to public adjusters, people who could be on your side to help you generate those lists and provide the information to the insurance company in a way that they'll respond. Typically, there's the money the insurance company knows it has to pay, the stuff that it will do after you provide documentation, and then the more difficult money, or sort of easier money, moderately difficult money, and then hard money to be able to obtain as part of your claim. But they're required to set aside the total value of your claim and keep it there until there's a resolution of your claim. So if you've been paid out 50% so far, 75%, you may have some tasks that you need to do. You may need some additional help, say from a public adjuster or an attorney. But if you've already maxed out on your claim and you're underinsured, then you might want to consider other alternatives like utilizing a Department of Insurance complaint or speaking to a lawyer who could address those types of issues. Again, you have the backstop of bringing it into the PG&E litigation, saying this was my uninsured losses. But again, we're not clear on how much of any one person's losses are going to actually be redeemed in the process. Hopefully that'll be better than we think, but we just don't know. Yeah, is that fair to say, Helen? A little maybe off topic.
No, it's a big topic, and we actually don't have enough information to do a whole program on it. I hope that will change over the next few weeks.
Yeah. Let's see, I think getting close here to the end, we have just a few more minutes, about 10 more minutes that we'd scheduled, but not too many additional questions. Bear with me a sec. Yeah, there was a comment from Karen Goins, who was one of the members of the TCC who did resign recently. And she writes, our purpose for resigning from the TCC is to bring to the public the issues. The plan will be more likely to make better options for the fire victims. We have to have a better plan, yeah? So that sense of resigning in protest in the hope that it will become a better plan. I think many people are hoping for that in general, like maybe we wait a little longer, we see what happens. We know people are still negotiating on our behalf.
Three members of the TCC resigned because they could not support the current plan, and they didn't feel that fire victims were being told the truth. I think it summarized what they were feeling. And I can say that that's a very unusual event. It's been a tough case. We that could be another forum, is digging deeper into that event, that what brought that on and why.
Yeah, yeah. I think a lot of people are curious about that. Yeah, because many of those people who were part of that process were fire victims just like us. And so when they're taking that stand, that means something potentially to look at, even if you've already voted. A couple of people have talked about the voting process and whether can you change your vote? Can you change your vote more than once? What's the process around that? Do you have a sense of how that works, Helen?
You can change your vote. I believe you have to get a new ballot number and submit a new ballot. And I believe the online ballots trump the written ballots. So I just let you know, it can be done. But try to do it a couple days ahead of the deadline, because I think it's a little bit more complicated than just voting the first time. But keep that option open. I also understand that you can vote no, and PG&E can come back and try and convince you even after the deadline to vote yes. That's what I've been told by one bankruptcy attorney.
Oh, I hadn't heard that. Interesting. There were a couple of threads too around the taxability of the settlement, and I know that's kind of a bigger issue and it's somewhat personalized in some ways, but are there some aspects that you feel comfortable speaking to around the taxable dimensions of any settlement here?
I'm not a tax attorney. No, it's an individual case by case. I'm not comfortable answering tax questions.
Yeah, there's a lot of variations in terms of how you're situated and understanding, what amount of proceeds that you're receiving from the insurance, how does that relate to your tax basis and your original property? And so like maybe some people inherit it, some people purchased it, there's a lot of questions, what improvements you made in your property, all that's the domain of the tax accountant. And there's plenty of good ones, I think, in these communities who've had a chance to look deeply at these issues, given the scope of people in the neighborhood who've had to go through this. So it's not like recreating the wheel at this point. They know what the rules are. Like you may find if you've moved away and you're now living in Nevada, it may be harder to find good tax advice to the degree that you're dealing with disaster issues like this, federally designated disaster areas, plus insurance proceeds, plus the settlement here. There's a lot of variations that maybe not every CPA on Main Street will know the answers to. So if you can reach out to other communities or reach out to any of the victim advocacy groups to see who are some of the law firms, or if you need tax attorneys or CPA firms that are familiar with these issues and can give some advice, because it does vary significantly on your individual situation, your insurance settlement, and the tax basis of the things that you had.
And let me also bring up some people who are on public assistance. Before you get payments on the PG&E from out of the trust, you would probably want to set up what's called a special needs trust. And you can email me. I've been in contact with a law firm in Napa that helps set up special needs trusts so people don't lose disability benefits or other public aid. It can be done. Some law firms who are representing clients are helping them with that process. If your law firm is not, again, email us and I will send you the contact information for a law firm in Napa that's helping people.
Okay. So I think we're getting then to the end of our questions for the most part here for today. So probably we can look to wind down our session a little bit early. Okay. I did want to say again that, even though we're lawyers, we're not coming to this in terms of offering legal advice. This is not our area of expertise, but it's something that we've come to sort of look at as legal information. Like some of this stuff might be related to like terminology, being able to explain some of the concepts. We can do that because we can understand it, but it's, I should say, it's, we're just speaking as survivor to survivor more than anything here. Yeah, Helen, do you want to add anything on that subject?
Yeah, that is this general information to actually how this general information applies to you and your family and your situation. That's when it crosses into legal advice, and you need to have an attorney working with you to do that.
Yeah. And also to understand the risk. I think everybody is approaching the yes or no decision from a different place, as I mentioned earlier. And so we don't know, everybody's going to have a different risk profile in a way. And so I'm trying to sort through the information to see what is that fact, what is interpretation, what's opinion, and how does that affect the risk, and sort of what's speculative about this? How do I know what's speculative here?
And I wish people would not attack each other, which is happening on Facebook, that how could you vote yes? How could you vote no? You're hurting me, you're hurting my family. Um, that's not really fair. I think there's, as you said, there's a lot of unknowns, there's a lot of risk. There's a lot of sense of injustice. There's a lot of sense of fear. And everyone, I think, is coming to this decision honestly and very personally, and we should all respect each other.
Yeah. And I guess I look at it too, like, we're sort of a train going through the tunnel, even in PG&E's eyes, right? Like, they got to get all the cars through, or at least 2/3 of it through, if they have a chance of it being voted yes, unless the bankruptcy court interferes or says, well, even though they said no, we're going to say yes, and cram down effectively the victims. But so far, the judge has been listening and indicated that he'd be less likely to do that, I think, in some sessions. And so it becomes this question of getting us all through the tunnel together. And so if people don't have information, then it puts them at a disadvantage in terms of making that vote. And I think it's important, the more of us that we, I kind of think of myself as a caboose, like, and that's how I've been a lawyer in the past. How do I get the whole train through the tunnel? I'm not the one driving it, but we have to make sure that everybody has the information that they can vote, and do so in an informed way. So it's to our advantage if you already even have decided to be able to share people your recommendations, or what your view had been, or what your calculus had been in making the decision, or how you assess the risk. Maybe that's helpful to some of your friends. So great. So I think we're just at the tail end then. I'll mention that this will be posted. I may make a little bit of editing just from the technology perspective, but in general, we're going to post it just the way that it is. We'll try to get the slides up as well in the next day, and we'll continue to be a resource for the community, we hope, and looking at these issues as they evolve. And check back with firesurvivorsvote.com from time to time, and we'll be announcing new things there, as well as through flyers and various community chat boards and social media areas. So Helen, thank you so much for your informative presentation. I know you took a lot of time, and over the course of this whole 2-year process of the bankruptcy and the recovery, to inform yourself on Prime Clerk and read the documents and know what's updated and what's not. Like, there are thousands of documents out there, and even for me, going on, like, I went on maybe 6 months ago for the first time. Knowing where to start is an almost impossible task. And so having your benefit of paying attention all that time, on top of all the other things that you and your family had to address, it's really offering us all a gift. And I really appreciate your time and effort to do it, putting together slides, things that can be shared and make a difference. So thank you again for your efforts.
Thank you. Thanks for making this happen, and thanks for doing my slides for me.
Yeah, we're just like water, we fill in all the cracks, I'd like to say. So we do whatever we can. So thank you, everyone, for paying attention today. Again, we'll continue to post new updates on the firesurvivorsvote.com and through the various community chats and social media fora that are out there. All the best, everybody, in the decision.
Thank you, everybody.
Process. And keep us informed about your questions or comments, what your needs are, and we'll do our best to put information out there as soon as it's available. Thank you.